In 2011, the Department of Aboriginal Affairs and Northern Development Canada informed the bands in the Maritime Provinces that they were going to change the social assistance rates on reserve in Nova Scotia, New Brunswick, and Prince Edward Island to match those off reserve. The chiefs immediately knew that this would result in major cuts for their social assistance clients and needed to find a way to stop this from happening. So the Assembly of Nova Scotia Mi'kmaq chiefs joined Mi'kmaq and Maliseet chiefs from New Brunswick and Prince Edward Island in a lawsuit to stop the government from implementing their new social assistance policy. All 30 chiefs in the Maritimes filed their case, and their lawyers were successful in getting an injunction to stop the cuts from happening while the case was being heard by the courts. In November 2013, we won our case at the federal court, and the judge had said that Canada had failed to study the impacts these cuts would have on our people, nor did they consult with First Nations about their new policy. Canada appealed this decision, and in January 2015, the Federal Court of Appeal sided with the federal government. The chiefs from Nova Scotia, New Brunswick, and Prince Edward Island refused to leave the case there. They have applied to have their decision appealed to the Supreme Court of Canada. Right now, we are still waiting to hear whether or not the Supreme Court will hear our case. So why did the chiefs take this to court? This new social policy will be very hard on our people. Although Canada has said that they were doing this to make social assistance on reserve comparable to off reserve, the fact is there are a number of programs offered off reserve that would not be available to our clients. This will affect what programs our people can access and the dollars they would receive. Canada's policy is forcing the bands to make major cuts to social rates for both families and individuals. It removes shelter and power allowances and makes cuts to diet supplements, as an example, for persons with diabetes and pregnant and nursing mothers. Checks will have to be issued on monthly rather than bi-weekly basis, which we know will be difficult for many people to adjust to. So people have asked, then why don't the bands just say no to the federal government's plan? Canada has said that if we don't implement their plan by April 1st, 2016, then the bands will be listed as non-compliant. What does that mean? It means that dollars for the band's projects and services could be frozen, and there's no question that none of the bands could afford that. If we win, what will we get? The chiefs want the authority for their bands to make the decisions for their communities when it comes to social assistance. They don't want the federal government to introduce changes without consulting the bands or without having a true understanding of the unique situations and circumstances that our communities face. The bands in Atlantic Canada have adapted social assistance rates and standards to reflect their community needs for nearly 30 years. They will continue to stand united on this so that they can do what's best and right for our people. For more information about this case, visit www.mi'kma'rights.com.